call this meeting to order. I call this meeting to order. Good morning. We're going to begin this evidentiary hearing with Tina Emerson. I'd like to ask a couple of questions. Is there any representative from Duke Energy present pursuant to the subpoena issued by the board? If so, please state your name and bring me any document you are producing in response to the subpoena. Any representative here from Duke Energy? Do I have a representative from the town of Lake Santeetlah present pursuant to the subpoena issued by the board? If so, please state your name and bring me any documents that you are producing in response to the subpoena.
I would note that the town did provide responses last Friday, but I think they're circulated. I want the chair to be aware that I think those documents have been produced in advance of the hearing.
Thank you.
Madam Chair, I'm sorry, but they were produced under objection.
Thank you. Is John Emerson present?
Yes, sir, ma'am.
I would like to ask you if you have brought any documents that we requested that was in response to the subpoena that we issued, sir.
No, we objected to the subpoena, and we responded last week.
Is Tina Emerson present?
Yes, ma'am.
Have you produced and brought any documents that have been requested in response to the subpoenas that we issued?
No, ma'am, we responded last week, we objected to the subpoena.
I want to stop for 1 second and ask the clerk if you can, the report, can you hear? Not very well.
Maybe, I think the fan is a little hard for me.
That kind of helpful. Ms. Emerson? Ms. Emerson, could you repeat what you said?
I'm sorry, I said that we responded last week that we objected to the subpoena.
Anytime that you cannot hear, please stop me and let us know legally.
Thank you.
Is Teresa Garland present?
Yes, ma'am.
Is Jim Hager present?
Present.
Is Susan Robinson present?
Present.
Would you please raise your hand? I can't tell. Thank you.
Madam Secretary, I make a motion that we go into closed session to seek advice from our legal counsel.
Second motion.
We will go into closed session for under 143-318-11A3 to consult with an attorney employed or retained by the public body in order to preserve the attorney-client privilege between the attorney and the public body, which privilege is hereby acknowledged. General policy matters may not be discussed in closed session, and nothing herein shall be construed to permit a public body to close a meeting that otherwise would be open merely because an attorney employed or retained by the public body is a participant. The public body may consider and give instructions to an attorney concerning the handling or settlement of a claim, judicial action, mediation, arbitration, or administrative procedure. If the public body has approved or considered a settlement other than a malpractice settlement by or on behalf of a hospital in closed session, the terms of that settlement shall be reported to the public body and entered into its minutes as soon as possible within a reasonable time after the settlement is concluded. And do I will now go to a vote. We had a motion and a second. All in favor? We're now going to go into closed session. We ask you to please step out in the lobby for a few minutes. Do I hear a motion to go back into open session?
I make a motion to go back into open session.
Is there a second? All in favor? Aye. We're now back into open session. The subpoenas that were objected to are not returned by Duke Power and the Emersons. Mr. Miller, since you were the party that requested the subpoenas, do you want to proceed or postpone this hearing?
Thank you, Madam Chair. First, I'd like to note that the objections to the subpoenas are not valid objections. I'd like that put on the record. They note in the objection that they call them procedurally defective. The chair of the County Board of Elections does not have the legal authority to issue subpoenas. As the board is aware, you all decided to issue these subpoenas, and you authorized your chair to sign those on behalf of the board. There's nothing in the state statute that requires each of the members of the board to sign the subpoena. Essentially what the Emersons have done, despite having a subpoena that says from applicant, Board of Elections, they've said, we don't want to give you the documents, and we're not going to. At this point, what I would suggest is that we proceed with the evidence that we have, and that I would essentially hold on to that decision about whether we would ask the board to enforce the subpoenas until after we've gone through our evidence, instead of making that decision at this time, so that we respect your time. You've taken off work to be here today, handle the part of the hearing that we can, and then if it's necessary to get those documents for the board to go to court, of course, the Emersons to produce what you've asked for, we can do that after we presented our evidence. If that would be agreeable.
Can I comment, please, ma'am?
Yes.
Okay.
And just as a housekeeping matter, we have two matters here. One is for John Emerson, one is for Miss Emerson. And those individuals are not represented by counsel, so they would not be able to speak in each other's hearing. So I just want to make that clear for the record as well. As neither are an attorney that could represent one another.
Are you suggesting one of the spouse cannot call the other spouse as a witness?
No, I'm just saying if Mr. Emerson was going to be speaking or representing or attempting to represent Miss Emerson in her hearing, he can't do that and vice versa.
Well, there'll be double objections on everything then. We objected to the subpoenas on the grounds of Rule 45, which states, the subpoena fails to allow reasonable time for compliance. We got these subpoenas within a week before this hearing, last Wednesday or Thursday. The subpoena requires disclosure of privilege or other protected matter, and no exception or waiver applies to the privilege or protection. And I'll touch on that when we read what the board asked for in the subpoena. The subpoena subjects a person to undue burden, which is, you'll realize quickly once I read the subpoenas to you. The subpoena is otherwise unreasonable or oppressive. You'll realize that also. The subpoena is procedurally defective. We have a letter from the attorney for the town of Lake Santeetlah, who's objected to the subpoenas for the water bill, stating that the town objects to the subpoena because it is procedurally defective. The chair of the county board of election does not have the legal authority to issue subpoena for records. Okay, I'll just read about the authority of the state board chair. We believe the state board of elections has that authority because that's in statute. It says upon written request or request of two or more members of the state board, the chair shall issue subpoenas for designated witnesses or identified papers, books, records, or other evidence. In the absence of the chair or upon the chair's refusal to act, any two members of the state board may issue subpoenas, summon a witness, or compel the production of papers, books, records, and other evidence. So we did not get a subpoena from the state board. We got a subpoena from here, from the county board. Now, I'll read, if you don't mind, what Mr. Knorr asked for, and subpoenas that were issued by you, I guess done by him. All credit card and debit statements for the accounts used by Tina Emerson and John Emerson from January 2020 through the present. All state and federal tax records, including amendments from January 2019 through the present. Federal tax records, as we all know, are protected by federal law. Only a grand jury of the United States can issue subpoenas for tax records, and they are highly protected. And we see no reason why they have any bearing on this case. All versions of any state driver's license or identification cards for Tina Emerson and John Emerson for 2019 through the present. All versions of any passport or passport applications for Tina Emerson and John Emerson 2019 to present. All vehicle registration cards for any vehicle used by Tina and John Emerson 2019 to present. All leases of real property signed by Tina Emerson or John Emerson 2019 to present. All deeds to real property signed by Tina and John Emerson 2019 to present. All property tax bills for any real estate or any property owned by the Emersons 2018 to present. All receipts or other proof of donations made to charitable organizations made by Tina and John Emerson. All receipts, invoices, or other documents showing proof of membership in a gym, in a pool, in a country club, or other membership based on the entity in which Tina Emerson or John Emerson is a member, user, or lead. All receipts, invoices, or other documents showing the use of a kennel or a veterinarian by any animal owned, fostered, or housed by Tina or John Emerson. All affidavits or other notarized documents signed by Tina Emerson from 2019 to present. All bank account or other financial statements for any account used by Tina Emerson and John Emerson 2019 to present. We all know bank records, financial records are extremely protected, and again, grand jury subpoenas are needed for that. All telephone, mobile phone statements for any account used by Tina and John Emerson from 2019 to present. All I-9, W-2, employment benefit, or other employment-related documents that indicate Mrs. Emerson's address and were signed or submitted by Tina Emerson or John Emerson 2019 to present. All gas station, home improvement, grocery store, pharmacy receipts, invoices, or other documents showing purchases by Tina or John Emerson. All loan applications signed or submitted by or on behalf of Tina Emerson or John Emerson 2019 to present. All other applications, contracts, documents signed or submitted by or on behalf of Tina and John Emerson on which Mrs. Emerson's address is indicated. These include but are not limited to credit card applications and contracts for the purchase of real property. All medical records, which again, I'm reminded are protected under the HIPAA laws, or documents submitted to a medical provider including an address for Tina and John Emerson 2019 and present. All mortgage statements for any property in which Tina Emerson has real property interest from 2019 through present. All pay stubs from Tina Emerson 2019 to present.
Madam Chair, if I may.
I'm not done, sir. I'm not done.
I'm addressing the chair. So Madam Chair, if I may, I'd like to review my objection. I believe Mr. Emerson was reading from the subpoena issued to Ms. Emerson. This was the point that I was making. Again, he is not entitled as a non-attorney to represent her or make arguments on her behalf during her hearing.
The subpoenas, you said, Madam Chair, Tina or John Emerson on both of them?
Subpoena at the top says to Tina Emerson. We are dealing with Tina Emerson's hearing first. If Mr. Emerson is representing her and making arguments to this court, and I will renew my objection and ask the chair to instruct him to stop. Not licensed as an attorney in this practice of law within the state.
Could I ask a question, request from volume everyone? The parties, both the challenger and voters that are challenged, consent that whatever argument is made with regard to the subpoenas in this hearing would be considered as made in the next hearing. So we don't have to get this.
Just for the purpose of the subpoenas,
Yes.
we would agree with that just for the purpose of the subpoenas, not at an issue.
Yeah, yes, we concur.
Is that true, Ms. Emerson?
Yes, please.
Thanks. I'm sorry to interrupt you.
That's okay.
It makes it easier because I'm just going to say the same
She was
thing.
just going to repeat what I just said. So I just want to go back after reading the objections allowed by law to these subpoenas. And now after reading to you the subpoenas, I just want to repeat why we were able to object legally and lawfully to these subpoenas. The subpoena fails to allow reasonable time for compliance. These subpoenas have literally asked for almost all of our records, everything about us, even our dogs, our doctors, our tax records, our bank records, for 4 years for a voter challenge case. We got these subpoenas. My wife was up here the whole time. I was out of the country. So when she returned to our home in Matthews, our mailing address, that's where these subpoenas arrived. So when she was out here in Lake Santeetlah for all that time, she didn't know that these arrived. So she got them some 6, 7 days late after, 8 days late after. So we were almost within the 10-day requirement there. I'm sorry. I just want to finish reading these. The subpoena requires disclosure of privileged or protected matter, and no exception or waiver applies. Tax records, medical records are completely protected. Financial records are completely protected by law. There's no way we would provide these records, and they do not apply to our case. The subpoena subjects a person to undue burden. Just imagine how many records that we need to supply to comply with the subpoena. The subpoena is otherwise unreasonable or oppressive for the same reason. The subpoena is procedurally defective. We've just given you information from an attorney for the town of Lake Santeetlah that this board has no authority to issue subpoenas. We've searched all the law. We cannot find anywhere where it says a county board chair can issue subpoenas. Only the state board chair can. And my guess is that person still has to go to court to do that. But subpoenas are issued by courts. So we just want to be on record with both of us that these are the reasons we're rejecting to these subpoenas. Thank you.
And just to follow up, since we're still talking about the subpoena, in order for the subpoena to be overridden by the objection requires a court order. And so that's what number 4 says on this Rule 45, which was supplied with the subpoenas. It says if objection is made under subdivision 3, which is what John just read to you, of this subsection, the parties serving the subpoena shall not be entitled to compel the subpoenaed person's appearance at a deposition or to inspect or to copy the materials in which an objection has been made pursuant to an order of the court. So the court would have to authorize this information.
And we would test that as a court or something.
With the board's consent, we'll defer our decision until the end of the day and proceed.
We just renew our objection until that time.
The board is in agreement that we continue.
Madam Chair, I'm sorry, if before we begin, I'd like to make another objection to the fact that this hearing is being held.
So noted.
Can I read the applicable statutes?
If you can, would you please catch your mic up just a little bit?
Okay. Yeah, I'm sorry.
And at this point, we ask that they be sworn in.
Yes.
Administer those oaths.
The Bible is waiting right here on the podium. Just like right next to it. Yeah, you can both put your hand out on it, both at once. Do you, John and Tina Emerson, solemnly swear or affirm that you are it's on the witness, so sorry. I apologize. Do you, John and Tina Emerson, swear or affirm that the statement and information you shall give in this hearing with respect to your identity and qualifications to be registered and to vote shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do. I do.
Is this objection also applicable to both of the hearings?
I'm sorry, I can't do that one, sir.
Is this objection going to be applicable to both?
Yes, for both of us.
And Mr. Miller, would you all, and would you all consent that we handle the same way we did the last one?
I'm happy for this objection to be included in the record for both hearings. Yes.
And you all agree with that?
Yes, we do.
Mr. Bisbee?
Yes, we do. The voter challenge form was submitted by Mr. Simon. And at the bottom of the form, she certified that this challenge is not based on a change of residence. In the instructions forms, page 2, oh yes, we have some copies we can give you.
I believe you have these already, which is an issue on the government.
Madam Chair, can we get a copy of that as well?
Now, this for Mr. Nora.
I think I may.
In the instruction form that was, is part of the challenge form, on the second page, it says, special note for residency challenges, and challenges filed within 90 days before an election. Pursuant to North Carolina Conference of NAACP versus the State Board of Election, and then there's the statutes. Voter challenges based on the following grounds are, in capital letters, not permitted, and no hearing will be held if based on the voter's change of residence. Or other qualifications without individualized evidence specific to the voter if filed within 90 days before an election. The North Carolina Voter Guidance Policy states, Section D,
Page 4.
on page 4, Section D, I believe I highlighted it for you there. Under change of residence, certain challenges are prohibited. Due to a federal court decision based on provisions of the National Voter Registration Act, and that underlined, no voter challenges may be based on a voter's change in residency. A voter may be removed for a change in address only if the county board has received written confirmation from the voter of a change of residency outside the county, or the county board has already complied with the National Voter Registration Act's notice requirement, and the voter has had no subsequent contact with the county board for 2 federal election cycles. Okay, and then State Board of Elections Memo 2018-7, which covers this specific topic, states underlined, no voter challenges based on the change of residency. Do not remove a voter from the rolls when a voter challenge is brought based on the change of residency. Do not hold a hearing or take any other action to consider a voter challenge based on a voter's change of residency. No voter challenges based on other qualifications without individualized knowledge within 90 days before an election. It's our contention that this challenge is based on a change in residency. We discussed this with an attorney. There were 2 cases, one in Buncombe County and one in Watauga County. The Watauga County was the exact same issue, and the County Board of Elections there voted 4-1 against moving forward based on these memos that the State Board of Elections, based on federal law, does not allow for hearings based on change of residency. We would ask that there be a motion to dismiss the challenge based on state law and federal law.
Mr. Nora, has anything to say?
Yes, yes,
One second, then I just, my wife didn't want to say something.
So I'll count it.
Okay, I'm sorry, we'll wait.
Mr. Nora?
Yes, Madam Chair, a couple things I'd like to highlight for you. In the packets that you were provided, the first thing that I noted from the board is entitled for you. The challenge certifies that this challenge is not based on the change of residence. That pulls this out of everything he just talked to you about. This is not based on a residency change. More importantly, let's look at what the rest of that memo says that wasn't quoted to you by Mr. Emerson. Challenges claiming that the voter has never lived in the address in question or challenges the alleged voter has moved within the same county are allowed. That's exactly what this challenge is. Our challenge says that they have never established residency in Graham County. They never were a resident here to register. They were never a resident here to vote. The number memo that they handed you expressly states that what he is arguing does not apply and you can proceed. So both the challenge indicate that it's not a residency challenge and your own state board's numbered memo says his argument doesn't apply and you can proceed. But also note that this is an argument that should have been made at the initial preliminary hearing. And this board has already concluded that probable cause exists, that they are not properly registered within the county. We'd ask that you deny the objection and proceed with the hearing today. Thank you.
I'll make a motion we proceed forward.
Ma'am, can I count on that, please, Madam Chair? based on this, lived at the address. We have voter registration cards from this county board that certify that we live at this address. So if you like, I can go through the registration procedure, 163 Paris 82. We were going to ask Teresa this during her testimony. But basically, what this says is the voter registration process takes place. There is a verification card that is sent to the person when they register to vote. If that card is not returned by the post office, that address is verified as the place where the person lives. Otherwise, we wouldn't have these cards. If the postcards were returned, the county board of elections say, you don't live at that address. But we have this, and we live at this address. So there's no evidence that we never lived at this address. We own the house, we have the deed, and this board certified that we live there. And by having this card, we are allowed to vote in this county.
That's also under the National Voter Registration Act, Section 8, clearly defines what every state has to do as far as setting up voters. And basically, if you haven't denied us from voting, originally when we applied, you confirmed that we are voters and that we live here. And so that's according to the National Voter Law, Section 8, which is part of the reason that the statutes, the North Carolina statutes, were changed because of a lawsuit. And so we contend that that sentence, lived here, does not apply based on already being certified that we do.
And so it goes on to say, the only way that we can be removed from the voter rolls is that the county board has received written confirmation from us that we have left the county. And you have not received that because we have not been. All the county board has complied with the National Voter Registration Act's notice required, and the voters had no subsequent contact with the county board for 2 federal election cycles. We just voted in the last federal election year, so we comply with that. It says right here, we cannot be removed from the voter rolls unless we go to you and say we want to be removed.
If I may, Madam Chair, that's not what that says. And I would encourage you to ask your own legal counsel as to whether that's an appropriate interpretation of the law, considering that neither of the Emersons are attorneys, neither of them have litigated elections disputes, and your own numbered memo from your state board tells you you can proceed. So we would, and I can...
This language is very clear.
Madam Chair, I would ask that I will pay the respect of not interrupting the Emersons, but ask for that same respect in return, if only for our court reporter here, so that she can accurately recount what is asked and answered from the witness. So if I can finish, I think they've lodged their objection. I think a motion has been made to proceed today. We ask the vote to proceed because your state board memo tells you you can. And the exact case they cite is in this memo, and the board concludes in a different way to the arguments they've made here before you this morning.
I'm sorry, ma'am, I just have one more objection. Attorney Norr mentioned that this should have been brought up at the preliminary hearing, but we were not given the option at the preliminary hearing to do anything, so we had no objection at that time because it was all one-sided. So that's the only thing I wanted to add.
In the preliminary hearing in Watauga County, there was an open discussion with the board members and both sides about the law and what applied and not applied. And so once all that was laid on the table, they decided that there's no grounds, and they specifically cited this memo, is there's no way that they can proceed with the hearing because it's specific, and you don't have to be a lawyer to interpret this. It says the hearing is prohibited. Do not conduct a hearing, do not take any action. That's what this says. This is the law.
Still make a motion tonight. Proceed forward.
I make a motion to second. You second the motion? Yes. All in favor that we proceed forward? Any nays?
This is the last part legal.
We're now going to have the board attorney, our attorney, Mr. Gilcan, give an explanation of the burden of proof and the order of proof for this hearing.
Urgent proof on the hearing is that everyone here will
Burden of proof in the hearing that we're having today, both hearings, will be upon the challenger. The standard that has to be met for an evidentiary hearing is different from the standard that we had in the preliminary hearing. The board's decision must be based upon substantial, material, relevant evidence to support the decision. Substantial evidence is such relevant evidence as a reasonable mind might accept as adequate to support a conclusion and is more than a scintillant or a permissible inference. The order of proof, since we'll go with the party having the burden of proof, presenting evidence first, subject to cross-examination, then the challenged voters will have the opportunity to put evidence up. That's the procedure we'll be following.
Mr. Chairman.
One of the procedural aspects of this is the chair is required to explain to the challenged voter the qualifications for registration and voting in North Carolina. I believe that the chair is about to do that.
The only person that we have at this time that's for this hearing is Tina. It's our first one, Ms. Tina Emerson.
Madam Chair,
I'm
I'm
going to
sorry.
read to you the qualifications for vote. Only such persons as are legally registered shall be entitled to vote in any primary or election. Every person born in the United States and every person who has been naturalized and who shall have resided in the state of North Carolina and in the precinct in which the person offers to vote for 30 days next preceding an election shall, if otherwise qualified, be qualified to vote in the precinct in which the person resides. Persons under the age of 18 and persons who are judged guilty of a felony against the state of North Carolina or the United States, or are judged guilty of a felony in another state that would be a felony if it had been committed in this state, unless that person shall be first restored to the rights of citizenship in the manner prescribed by law, shall not be allowed to vote in this state. Residence, when used in the election law, means domicile. Domicile denotes one's permanent, established home as distinguished from a temporary, although actual place of residence. When absent therefrom, it is the place to which he intends to return. It is the place where he intends to remain permanently or for an indefinite length of time or until some unexpected event shall occur to induce him to leave. Two things must concur to constitute a domicile. First, residence. Second, the intent to make the place of residence a home. I administer the oath. There's a second oath now that I have to know. Okay. So I want to ask the board at this time, each board member, if they have any questions for Ms. Tina Emerson before we begin. I have one if no one else does. I have one question for you, Ms. Emerson. Are you qualified to vote in the Topeka precinct, Grant County, North Carolina?
I am.
Is there any other questions for the board? I will now administer the second oath. Would you put your hand on the Bible, please, Ms. Emerson? You do solemnly swear, Tina Emerson, or affirm that you are a citizen of the United States, that you are at least 18 years of age or will become 18 of the date of the next general election, that you have or will have resided in this state and in the precinct for which registered for 30 days by the date of the next primary or election, that you are not disqualified from voting by the Constitution and the laws of this state, that your name is Tina Emerson, in such name you were duly registered as a voter of the Topeka precinct, and that you are the person you represent yourself to be, so help you God.
I do, and I am, and yes. What's yours?
Are you ready to proceed with your case? Thank you, Ms. Emerson.
We are, Madam Chair. I won't rehash some of the guidance that your attorney has provided you, but I do want to hit on a few different points and why we're here today. I appreciate that each one of you, many of you have jobs, you had to take time off of work here to listen to an important issue, and that issue is something that I think we all can agree on. Everyone has a right to vote where they reside. But Tina Emerson doesn't reside here anymore. What my client is asking you to do is to prevent her from continuing to dilute the vote of Graham County real residents by engaging in voting in a community where she does not reside. You've heard it from her husband at the beginning. Our home in Matthews. That's how he described receiving the subpoena. I've not even asked or submitted the first piece of evidence. He's admitted to his home being in Matthews, North Carolina. You're going to hear today from several witnesses that lay out not just their opinions, but the facts. You're going to hear from Diana Simon. Ms. Simon is a council member in the town of Lake Santeetlah. She was shocked at the end of last year at the election when she saw that several people who registered to vote who do not reside within the town. She's collected photographs of Ms. Emerson's home documenting when she's not present. She has collected information about deeds and deeds of trust where the Emersons have made representations to their lenders about where they would and wouldn't live permanently. And we're going to present that information for you to evaluate today. You're also going to get to see information that Ms. Emerson herself has provided in the form of political donations. As the board is aware, in this state, when you make a donation, you are required to indicate where you work, where you live, and who you're providing that donation to. That information is a public record kept by the State Board of Elections. Even after filing her registration, claiming to be a resident of Graham County, Ms. Emerson continued to list her Matthews address as her residence when she made donations in late 2021 and even this year. And that is just a thumbnail of the evidence that we're going to present. You're also going to hear from Jim Hager. Mr. Hager is also a member of the town council. He has taken pictures documenting that the Emersons are not. You will hear that they have spent more time outside of the town of Lake Santeetlah than they have inside. You're also going to hear from Susan Robinson, who owns a home across the cove from where the Emerson's lake house is located, who will corroborate what Ms. Simon and Mr. Hager will present to you in documentary evidence. And at the end of the day, we're going to ask you to make a decision that is consistent with the evidence we presented to you, which is that neither of the Emersons have ever resided in the town of Lake Santeetlah. Yet because she wanted to be on town council, she changed her registration to then run a write-in campaign in order to win a seat on the board. She doesn't live there now. She's never lived there. And we want the board to make that determination as part of your work today. Our first witness, our first witness will be Ms. Simon. There are a few things that I want to go over that relate to your work this morning. The first is some of the law that we're dealing with. Again, I think your chair hit it very well. Your residence, and this is out of the general statutes, is the place where a person's habitation is fixed, to which, whenever that person is absent, the person has the intention of returning. Section 3 at the bottom here. Persons shall not be considered to have gained a residence in any county, and to which that person comes for temporary purposes only. And what that means is just because you buy a lake house doesn't mean you become a resident of that county because you come and visit your lake house. Your residence, where your home is where it's fixed and permanent. Another part of this, and this is from the Farnsworth case, this is a Court of Appeals case that's citing the North Carolina Supreme Court. When where someone retains his original home with all of its incidental privileges and rights, there is no change in domicile. You've already heard from Mr. Emerson. Their home is in Matthews, North Carolina. They purchased that home in and around 2005. They've maintained that residence. Simply buying a lake house in Lake Santeetlah does not change your domicile, particularly when you retain the home that you still use. Types of evidence. This is what you're going to see today. I marked these from you. These are the kinds of things that show where someone is a resident, the things you should look for. And starting here at the bottom, we look at, try to zoom in here. Look at what the legal documents say. In this case, it was a lease. Today, you'll see deeds and deeds of trust. You look at where the testimony goes. That's number 3. Do people see them there? Are they gone? Neighbor testimony. That's number 4. Utility accounts. That's why you subpoenaed the documents you wanted. You asked for utilities because you wanted to see what does the electric bill look like, what does the water bill look like, what does your phone bills look like, because it shows where you're using utilities. Look at the testimony given by spouses. In this case, Mr. Emerson has already told you that his home is in Matthews, North Carolina. Their home. Look at other documents, insurance, automobile, home, personnel, the kinds of documents you asked for in the subpoena. Tax returns, again, documents you asked for but haven't been produced. Memberships, are they members of clubs, gyms, churches, things like that. That would indicate where you live, where you reside. And at the end, driver's license numbers, number 10. Where does your driver's license say? This is it's not the only example of evidence. So these are examples that courts have said are related to where someone was born. The other thing, and you heard this during the preliminary challenge and you'll hear it today, is what prima facie evidence is. We produced to you, and we have it here today, my client, Ms. Simon, mailed correspondence related to her work at the town to the Santeetlah address. It was returned undeliverable because the Emersons don't live there. Under state law, 16385, that constitutes prima facie evidence that the person no longer resides in the precinct. In this case, they never did. We have that, we'll produce that to you. But what does prima facie evidence really mean? That's, Bill and I use these words, and sometimes we assume that everybody understands what that means. And if I was a lawyer, I wouldn't have a clue. But the courts have told us, prima facie has been defined as a cause of action or defense sufficiently established by a party's evidence to justify a verdict in his favor. Meaning, the evidence of that mailer is sufficient for you to conclude that she is no longer a resident of Lake Santeetlah, provided the other party does not rebut such evidence. So once we produce this to you, produce our evidence, it is on them to rebut that evidence. And you are entitled to come to that conclusion simply by receiving the mail. With that said, I'd like to move on to our first witness, unless the board has any questions at this time.
Does anyone have any questions? Proceed.
This time we would call Diana Simon.
Ms. Simon, if you put your hand on the Bible on the initial of the oath. The Bible's on the podium on the other side. Do you, Diana Simon, swear or affirm that the testimony or statement of information you shall give in this hearing with respect to your identity? Wrong one. No, that's it. Qualification to be registered and to vote shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am, I do.
Good morning, Ms. Simon. Can you give the board your full name for the record, please?
Diana Bonham Simon.
Ms. Simon, what do you do for a living or did prior to retirement?
I am retired now. Previously, I was a graphic designer in Atlanta and worked with educational marketing. Also owned a bed and breakfast and managed having guests for 15 years. Before retiring here in 2016, I originally bought my home at Lake Santeetlah in 1990.
Prior to that time, prior to retiring, you were registered to vote in Georgia, correct?
Yes, that is correct.
That's where you lived, that's where you worked, correct?
Yes,
Okay. So upon retirement, did you sell your home in Georgia?
yes, we sold our home.
Okay, and you moved to Lake Santeetlah into the lake house you have up there permanently, correct?
We have been here permanently since 1st of November in 2016.
And you say we, who else did you live with?
My husband, Joe.
Anyone else live with you?
No.
Do you have any positions with the town of Lake Santeetlah?
I am a town council member, and I'm also chairperson of Tourism Development Authority.
How did you, I mean, why have you gone to the efforts you've taken to file this challenge? How did you get involved with that?
Well, I'm very involved in my community, and after the day after the election, I was a bit surprised to see that I had received 22 votes. This is a little bit high for the number of people who vote in Lake Santeetlah. I went to visit the Board of Elections office. I talked to Tasha. She indicated the link on the North Carolina site to give me information about the election. And I was surprised to see that there were more people registered to vote. I checked in with Teresa Garland the next day, questioning and letting her know I thought that there were some irregularities for the election. Later that day, Bob Weir had provided me with a listing of registered voters. And it was different from the listing that I had received from the Board of Elections in August. And the listing showed 11 people had registered to vote between August 31st and October 6th. And I knew of these people that had registered to vote during that time, that they did not actually reside full-time in our town.
So essentially you get this list that shows 11 new registered voters, and you're saying yourself that they don't reside in the town. What did you do after that?
I did mention it to Mayor Jim Hacker, my concerns.
Okay. And after that, what did you do to sort of dig into whether these folks were actually residents based on your suspicions?
I did start doing some research. I started observing the homes where these people had said that they lived. Some of them were abandoned. I knew that some people only came up for the summertime, that they actually had a home in Florida, where they had a homestead exemption. Another person lives in Marietta, Georgia.
Well, out of respect for the board's time, let's just keep it to Miss Emerson.
Okay.
That's why we're here today. So I'm showing here what's been marked as Exhibit 1.1. Board members, there is a white binder in front of you. This will have all of the exhibits that I put up on the screen. You can, they're in chronological order, so you can follow along. This will be right in front. Feel free to take notes. That's your copy to keep as part. Yes. registration form you were given by the Board of Elections when you asked for it.
Yes, I have requested public records on November 17th from the Board of Elections. And it wasn't until I had to request it again December 15th that I actually received the documents I wanted, the registrations of those people that I questioned.
And in the lower right-hand corner there, highlighted in yellow, does that indicate that this was filed by Ms. Emerson on September 28, 2001?
Yes.
We asked this be admitted into evidence. Madam Chair. Sounds like you requested some documents. Did you eventually start taking pictures from the public road to document when you saw Ms. Emerson at the resident, or I should say the Lake House? Is that correct?
Yes.
Okay. I'm going to throw these out, and they're also, again, provided in reminders. This is marked as Exhibit 2.1. This time I want to take a little bit of time with the exhibit stickers here, just so everyone can follow along here. So under that, it says Exhibit 2, the matching above, and then it has a set of numbers. This one says 2021, and then it says 11, and then it says 11. Correct?
Yes.
Is that indicating that this picture was taken on, again, November 11th, 2021?
Yes.
Okay, and is that a consistent format you've used across the photographs that you've taken?
Yes.
Okay, so you'll see the exhibit number at the top, and then you'll see the date the picture was taken on. Is that correct?
Yes.
So, is this a photo that you took?
Yes.
Okay, what is this of?
This is of the house that Emerson's owned at 124 Santeetlah Trail.
Okay, and this is the lake house they claim to reside at, correct?
Yes.
Okay. And on this date, were they present on November 11th?
No, they were not.
Okay. To be clear for the board, were they present at any time that day other than when you took this picture?
Nothing I'm aware of.
Okay. And is that consistent with all the photographs you took?
Yes, sir.
So you only took a photograph if they weren't there, and not just when you took the photograph, but throughout the entire day, correct?
Correct.
We're going to go through this, and I hate to belabor the point, but there are a lot of photographs, but we'll go through them one by one. I'll ask again, Madam Chair, that these be admitted into evidence versus throughout. That's all right. Okay. Marked here is Exhibit 3.1. Again, is this a photo that you took, Ms. Simon?
Yes.
This is a fair and accurate picture of the residence that you saw that day?
Yes, this is from December.
December 14th, 2021?
2021.
And the Emersons were not present that day either?
No, they were not.
In red here, I've circled that. What is that? And what's the significance of that?
That is a trash can liner.
Okay, so you, as part of your review of the house, you looked for whether things had been changed between pictures?
Yes, sir.
Moved? Okay. Exhibit 4.1, this is from December 15th, 2021, correct?
Yes.
Again, it's a fair and accurate photo that you took of the lake house?
Yes.
And again, is that attached trash liner essentially the same place?
Yes, sir.
Exhibit 5.1, this is from December 16th, 2021.
Yes.
Again, fair and accurate copy or representation of the house, and the Emersons were not present that day.
Yes.
Again, what can you tell us about that trash bag liner?
Same position.
Exhibit 6.1. Is this from December 17th, 2021?
Yes, sir.
Fair and accurate representation of the house as you saw it that day?
Yes.
Emersons were not present?
Not present.
Trash bag liner in essentially the same location?
Yes.
Exhibit 7.1. This is from December 19th, 2021?
Yes.
And fair representation of the house as you saw it that day?
Yes.
The Emersons were not present?
You were not.
Okay. Trash bag line are in essentially the same location.
Yes.
Exhibit 8.1. Instead of going through these questions every time, would you have the same answers as you previously given for exhibits 2 through 7?
Yes.
And this is from December 20th, correct?
Yes.
Exhibit 9.1, from the 21st of December.
21st.
Exhibit 10.1, from the 22nd. And Diana, we're starting to get into a flow, and I know that might be a little bit difficult for the court reporter, so make sure I finish asking before you answer, just so that she can get that. So exhibit 10.1, this is from December 22nd, correct?
Yes.
Exhibit 11.1, this is from the 23rd.
Yes.
Exhibit 12.1, from the 25th.
This is Christmas.
From December 27th, correct?
Correct.
This is exhibit 13.1. Exhibit 14.1, from the 29th.
Same position.
Exhibit 15.1, this is from the 30th of December, correct?
Yes.
16.1, this is from January 1st of this year, correct?
Yes, it is.
Same trash can,
Yes.
same liner, same location, correct?
Correct.
This is from the 4th of January, correct?
Correct.
Okay, so this is from the 7th, so I'll just go back from the 7th. We essentially left off at exhibit 8 through 17, where all of those exhibits, are those fair and accurate representations of the house as you saw them on those days?
Yes, sir.
Okay. And the Emersons were not present on any of those days, as shown. Looking at exhibit 18.1, this is from January 7th, correct?
Yes,
Emersons were not present, correct?
they were not.
Let's talk about the Suburban here. This is the first time we're seeing the Suburban. Can you talk to the board about the presence of the Suburban at the property?
It is a silver Suburban, and it's usually parked off in the parking area to one side, and it's not been parked where it would be seen in my photograph. Ms. Emerson was at the house on the 1st of January 6th.
Okay, so essentially that Suburban had been on the property in the previous photos. It just wasn't in your picture, correct?
That is correct.
And is this the vehicle that Ms. Emerson drives or uses, to your knowledge?
I've never seen Emerson's driving this vehicle.
And it permanently resides at the
It
house?
permanently resides in the house.
They don't use this to come to or from Lake Santeetlah, to your knowledge?
No.
So, did you receive, do you know why this may have been moved? Why the vehicle may have been moved?
Yes, sir. They have a camera on the house.
Let me pull that up. Is this what you're referring to? I'm going to exhibit 18.1. I've zoomed in to a small black box on the side of the house there. Is that what you're referring to?
Yes.
And why do you think that they may have moved the vehicle?
I know that they, or I feel that they were aware that I was driving the house.
Did you ever receive any letter from them about taking the pictures?
My husband and I went on holiday for 3 weeks in January, and upon returning, I think it was February 14th, I received a certified mail from Tina Emerson that was a cease and desist letter, pretty much indicating that I was stalking her. It was not prepared by an attorney, and my counsel told me not to.
Don't talk with, so the attorney-client privilege, let's not talk about what you talk with your attorney about, okay? And that goes for everybody.
I was on a private street.
Okay. Let's be clear here. This road here that you're standing on, this is the public road that goes through the town of Lake Santeetlah,
Yes.
correct? Okay, so you're not standing on anyone's property, you're standing on a public road, correct?
Correct.
Okay. And it's your opinion that they moved the car because they realized you were documenting when they weren't at the house. Is that fair?
Yes.
Diana, do you know, bottle of water, glass of water, something like that? I noticed that your voice has changed a little bit. Do we?
She can answer that.
Thank you. Looks like I think she brought one with her. Okay, we'll pick back up where we were at Exhibit 18.1. And this is again from January 7th, correct?
Yes.
And you noted that Ms. Emerson had been in town on the 6th, and the car was moved, correct?
Correct.
Okay. So, moving on to Exhibit 19.1, this is from January 8th, correct?
Yes.
Okay. You've got that trash can right there. Nobody's at the house that day, correct?
Correct. I took a picture from the neighbor.
So you could capture that trash can?
Yes.
This Exhibit 20.1 is from February 12th, correct?
Yes.
Okay. And I think you indicated that you and your husband went on a vacation.
Yes, sir.
Kind of explain to the board why there would be a gap there. So your last photo before that in Exhibit 19.1 is from January 8th, and then we go to February 12th, and we talk with the board about why that gap is.
We came back from our holiday in 14. That is on 12.
Okay. And when you were gone, was someone else taking pictures?
Jim Hager took pictures
Okay.
while I was gone.
So you get back from your vacation, you pick up where you left off. So February 12th, again, the Emerson's are not there that day, correct?
Correct.
Okay, this is Exhibit 21.1, and this is from February 13th, 2002. Again, that's suburban, that's permanently on property, it's located in this picture, correct?
Yes,
Okay, and Emerson's are not there that day, correct?
they are not.
What's the red circle here mean?
That is a post, their driveway, and this is to indicate where the car's position in that circle.
So essentially between the photos you picked, highlighting that the car's not moving, staying in the same place, correct?
Yes,
Exhibit 22.1, it's February 14th, the Emersons are not there that day, correct?
correct.
And this is looking at that suburban from the rear, looking out the windows, correct?
Yes,
Exhibit 23.1, from February 16th, the Emersons are not at the house that day either, correct?
correct.
And that red circle showing the proximity of that vehicle to the sign, correct? Exhibit 24.1, the Emersons are not there, and this is from February 7th, correct?
Correct.
Vehicle position in the same place, correct?
Yes,
Exhibit 25.1, from February 18th, Emersons are not at the house, correct?
correct.
Vehicles in the same location, correct?
Yes,
Exhibit 26.1, from February 19th, Emersons are not at the house, correct?
correct.
Vehicles in the same location, correct?
Yes,
February 20th, Emersons are not at the house, vehicles in the same location, correct?
yes.
Excuse me,
Yes, Madam Chair.
I'd like to take a 10-minute